Well, welcome everyone to our legal philosophy seminar, our third seminar of this term. As you can probably notice, the microphones are merely for recording purposes, so they won't actually project any sound. So if you can't hear any of the speakers, then please, so Sean, Robert, please come a bit closer. And also when we turn to our question period, we're going to just move the microphones around to record. So I get the pleasure today of introducing our speaker and our commentator today. So Professor Anver Emon joins us from the Faculty of Law at the University of Toronto, where he's associate professor. Professor Emon has shopped quite a bit around to get his degrees. He has degrees from a number of places, from UC Berkeley, UCLA, University of Texas at Austin, as well as Yale Law School. His research focuses on pre-modern and modern Islamic legal history and theory, pre-modern modes of governance and adjudication, and the role of Sharia both inside and outside the Muslim world. His recent book, Islamic Natural Law Theories, was published by Oxford University Press just in 2010. He has also co-edited a book, Islamic Law and International Human Rights, Searching for Common Ground, which is forthcoming. He is the founding editor of the interdisciplinary journal Middle East Law and Governance, and also serves on the editorial board of the Journal of Law and Religion. And he is currently working on a book titled Sharia, Rule of Law, and Pluralism. Today his paper is going to be an investigation of the concept of sovereignty in pre-modern Islamic thought. Our commentator today is our doctoral student in philosophy, Mohamad Al-Hakim. He holds degrees from McMaster, a BA and an MA. At McMaster, he completed a thesis entitled Liberalism and Minority Rights, which dealt specifically with the issue of faith-based arbitration. His main research interests are in multiculturalism, political theory, and legal philosophy. He's held fellowships at the Nathanson Centre, Human Rights, Security, and Crime. He's also published a couple of articles, one just recently in the Journal of Criminal Law and Philosophy, and has a forthcoming review in Transnational Legal Theory. Professor Emon will begin with a 30 to 35-minute presentation of his paper, followed by Mohamad's response, and then we'll leave the bulk of the time, as always, for questions with the audience and discussion. So please.
Well, thank you very much, and I want to first begin by thanking Michael for the wonderful invitation to be here, and the hard deadline to prepare something that I've been thinking about for a long time. It's nothing like a deadline to get something on paper, and I really appreciate that. This is very much a work in progress, and for me, this is not just an opportunity to present ideas, but hopefully to get some feedback on it, as I'm still very much in the middle of the project, and in that regard, I'm quite delighted to have Mohamad sitting next to me. We've met on a number of occasions and we've exchanged a number of ideas, so I'm actually more interested in what you have to say than what I have to say, frankly. And I hope that I look forward to learning from you as well, and from all of you. This paper comes out of sort of a long-term set of interests and questions that I've had, and I thought what I would do is, I'm not entirely certain I'll go for the full 30 minutes. I'm actually more inclined to get conversation going, but it stems from a series of projects that I've since completed, and there's a kind of genealogy to it, so I thought what I would do is explain how I got to this set of questions and then where I think I'm going after having discussed briefly what the paper is. So a few of the things that I've studied and tried to work on is when I did my doctorate in Islamic legal history at UCLA, the large question I was thinking about was the status of reason in Islamic law, and not so much as an epistemic matter, which we find in a lot of debates on the renewal of ijtihad. This is a common theme in a lot of late 19th, early 20th century literature, but really in a way that's more akin to what many in the West might call a natural law theory, and that then resulted in the book that I had published last year. And what came from that book was a recognition that Islamic legal theory is very much also hinged upon or built upon certain theological first principles. And that while in Islamic legal orthodoxy, for instance, if I want to use the term orthodoxy with scare quotes, There may very well be a considerable amount of legal pluralism, and it doesn't raise a question of heterodoxy. Where heterodoxy in Islam seems to be located is in the area of theology. And what I wanted to argue in that book, at least one of the main arguments there, was that regardless of what theological perspective you might start from, the competing theological camps nevertheless arrived at very similar jurisprudential positions. And part of my hope then was to suggest that while theology is important, it is not the end-all be-all, and it doesn't fully capture the full way, a robust way of thinking about reason. It doesn't fully represent, rather, the fullness and robustness of reason in Islamic legal thought. Rather, I was trying to carve out a space for legal philosophy as a distinct mode of inquiry within Islamic intellectual history. And politically, I'll be frank, the significance of that move means that one can avoid theological debates about reason and thereby remove themselves from ongoing contestations about identity and community that still resonate today. So to give an example, in that book I articulated two theological starting points, one the Mu'tazilite and the other the Ash'arite. And historically, the Mu'tazilites, who tended to be called the rationalists in Islam, were opposed to the Ash'arites, and the Ash'arites became orthodox, such that today, if one were to talk about reason in an open way like I try to in the book, I would immediately be called a Mu'tazilite and considered a heretic or outside the fold and easily dismissed. And part of what I wanted to suggest is one need not go the theological route to get to the questions of reason. Why is this significant? When Nasr Hamid Abu Zayd, the late Nasr Hamid Abu Zayd, who passed away about a year ago, in September, when he was writing about Quran and the Quranic hermeneutics in Egypt, he was deemed to be a Mu'tazilite, deemed by many then to be an apostate from Islam, and under a particular legal doctrine in Egyptian law, a group of right-wing conservatives sought to get him divorced from his wife on the grounds that as a Muslim woman, she could not be married to an apostate. And it became a serious cause célèbre in the early to mid-90s. It's since died down even before he passed away. But that is an example of why these theological categories still matter today. When a reformist group like Musawa, operating out of Malaysia today, tries to offer an approach to Islamic legal reform in the family, many of their scholars outwardly very robustly proclaim, I am Mu'tazili in my thinking, which I argue to them immediately is a point of departure from their ability to communicate very effectively across boundaries. And part of what Islamic natural law theories does then is to illustrate, one, the distinctiveness of theology and legal philosophy. While they're related, they are two very distinct disciplines, and one might be able to think about reason in a more proactive and productive way in the context of legal philosophy. And that was the one area that I was interested in. The second, though, has come through this current project that I'm working on Sharia, rule of law, and pluralism, Dhimmis and others in the empire of law, where I began to think about the intersection of political theory in the context of how do I render Islamic legal rules intelligible. So in the treatment of non-Muslims under Islamic law, the Dhimmis, the argument is by two different camps, these Dhimmi rules, which discriminate against non-Muslims living under an Islamic empire, some will say they are evidence of the inherent intolerance of Islam. Others will say they're mere academic jargon that actually doesn't reflect the historicity of Islamic history. So what we have then are two different myths: the myths of intolerance and the myths of tolerance, or the myth of persecution, the myth of harmony. And to get around the question of tolerance and intolerance, I wanted to argue in a Wendy Brown sort of move to suggest that actually these rules reflect a larger conversation about the discourse of governance, which then prompted the question, what do these rules reveal about the governance that animated these medieval rules from the 9th to 15th century? And there I argue imperialism. An imperial model actually helps make sense of these kinds of rules. And so from the theological to the legal philosophical in the first book, and then from the legal to the political, I'm interested in a number of different ways in which I can understand and then articulate what's going on with Islamic legal thought. And then the third project that it then led to was this collaborative project with the International Bar Association on Islamic law and human rights, And that has led me to this place where, in conversations with a few folks, it became very obvious to me that the conjunction "and" between Islamic law and human rights doesn't actually get at a robust sense of Islamic law in the international community. The human rights conversation is a very narrow one, and a particularly fraught one for reasons that I think actually cloud more of the conversation and interest that I have. And so it's in light of that, in response to that project, and recognizing the weaknesses and the limits of that project, I'm now thinking about issues of law and political theory as they relate to notions of international order or global community, or whatever you want to call it, collective ordering. And it's in that regard that I then come to this particular project, a project that, that is somewhat inspired by a considerable amount of literature since the 80s and 90s and in the early part of this century on what we might call Islamic international law. Islamic international law by many, and here I think of some folks like Sharif Bassiouni, who's better known in his international criminal law guise, but now is dabbling in Islamic international law, Javed Rahman from the UK and a few others. They write about Islamic law Islamic international law as if it has its origins in the work of Mohamad bin al-Hasan al-Shaybani, an 8th century jurist who wrote a book called Siyar, the Kitab al-Siyar, which is a medieval treatise on rules of treaty making and jihad, later commented on in a multi-volume, 8-volume treatise by as-Sarakhsi, who I believe was in the 12 or 1300s. I apologize for not remembering the death date. And they argue that this is the embodiment of an Islamic international law. And part of my question is that in looking at their work and looking at the language of this kind of literature, I've often noticed the language of the state is ever present. There's an assumption of the notion of the state. And in thinking about the imperialism that animated my previous project, I'm now beginning to wonder, well, how do you think about what those laws meant then as they manifest today in an international legal system? And this became a provocative set of questions for me when I had a conversation with Marty Koskaniemi and Karen Knopp. Karen Knopp is a colleague of mine at the law faculty, and we had Marty Koskaniemi about a year ago talking about international law. And when I asked him about this notion of sovereignty and what he thinks about the significance of sovereignty in international law, he pretty much laughed the idea away and said sovereignty is not particularly interesting for international law. One need not have a robust notion of it for international law to exist. I then asked Karen Knopp a similar question, and she thought Marty was off his rocker. And so there was an interesting tension that I have no stake in, admittedly. I'm not an international law theorist, scholar, or historian. I think it's unfair for me to say Karen thought Marty was off his rocker. That's me being a bit facetious. Karen, in a much more professionally responsible way, actually said that I actually think that the notion of sovereignty makes more sense in a post-UN charter fashion. And so I've been interested in that sort of question. So here's this paper. The paper here that I want to offer to you is thinking about whether or not sovereignty matters in Islamic law. If it doesn't, does it pose a real challenge to those writing about a so-called Islamic international law? And furthermore, whether or not there is a robust notion, does it really matter for the notion of global ordering or cooperation or whatnot? And in a moment, somewhat the paper actually has a number of different parts. The first substantive part having to do with theology, the second having to do with sort of political ordering, and the third having to do with treaties. The treaty section I haven't actually gotten to, but I will speak to you a little bit about it. I shared my thoughts with Mohamad in advance, so he would know where I would be going with this. And what I find interesting is the way, again, in which theology matters. Theology has mattered throughout the two projects that I've engaged in, and I believe it continues to matter here as well. And so I look at three different debates in early Islamic intellectual history: the debates on the nature of God, Him or itself, the notion of free will versus determinism, and third, the notion of what I roughly called the sovereignty of God versus the sovereignty of the ruler, whether or not these two notions can coexist. And the arguments are pretty straightforward in the sense of the first having a little bit to probably drawing upon, for those of you who are familiar with Euthyphro, it's a similar question about the good. Is God held to the good, or is what's good a function of simply God's will? and that being an important question that then impacts on the notion of free will and determinism, and God's justice in either allowing us to be free agents or moral agents, or rather conditioning us to act in certain ways, with implications of sanction or praise or blame as necessary. What I find in this particular context, and what I thought was interesting in the debates, in canvassing some of the pre-modern literature, was Ibn Rushd. Ibn Rushd, often known in the West as Averroes, and very much a commentator on Aristotle, has a fascinating treatise in Arabic on theology, and he basically suggests that both positions are problematic. He takes a position that it's not that we are either endowed with free will or that we are determined, rather we operate and we make choices within a frame, within a structure, within existing givens, and those existing givens are what he calls the asbab kharija, the external causes. And it seems to me that between these three positions, we have a question, at least, about the scope of agency, and therefore the sovereignty, at least of the self. And that plays into both the first and the second section of the paper, where the second I draw upon some of the work I did on the Islamic natural law theory material in terms of thinking about questions of the good and the right and our ability to actually engage those sorts of questions in a meaningful, reasoned fashion. The third section in the theological element has to do with an interesting conflation of a theological dispute with a political dispute in the early 9th century. In the 9th century, you had the Caliph Al-Ma'mun, who was an Abbasid caliph, who certainly fancied himself the scholar ruler, the enlightened king, whatever you want to call it. He certainly thought quite highly of himself as an intellectual, would sponsor considerable debates, but he also recognized that he was facing a crisis of some, well, not necessarily a crisis, but certainly a crisis of authority. There had been succession issues that he'd have to negotiate. He was trying to figure out the authority and legitimacy of the Abbasid Caliphate in light of what had gone prior to him and where it was going in the future. And he tried to, in a sense, assume a kind of religious authority that had been, up until that time, the province of the scholar jurists, or the ulama. And in a manner that was somewhat that was seen as rather controversial, he then proclaimed a particular orthodox position, an orthodox position associated with the Mu'tazilites, who we've now come to know as heterodox, having to do with the nature of the Quran. Is it created or uncreated? In the sense that the argument goes as follows: is the text a creation by God in history, in which case it's a created text, and the implication there being that the meaning of the text is subject to historical analysis and critical scrutiny in that fashion. Alternatively, it could have been an eternal text coexistent with God that isn't and is in fact removed from history. That would be the uncreated position. Ma'mun wanted the first, and he decreed the first as the orthodox position. And over a period of time after his death, 2 caliphs later, the policy was reversed. We associate the development of Asharism, or we associate the heterodoxy of Mu'tazilism with this historical political move, both the recognition of it by Al-Ma'mun and its reversal 2 caliphs later. And we locate the heterodoxy of Mu'tazilism oftentimes with this political decision. For me, though, what's interesting about the conflation of the political with the theological here is what it means about how we understand and engage the Quranic text and the implications of our own interpretive agency over the text and who can claim to be sovereign over it. And it raises important questions about the scope to which we can engage and interpret, as well as historicize without doing violence to God and to God's will. And then, so those are the three rather large theological questions that admittedly have more to do with the sovereignty of the self than of the political ruler, but has some implications on authority as outside the province of God, other loci of authority beyond just simply the divine. The third section is focused on the issue of political legitimacy, and this is an an issue that was particularly important for Muslim jurists after the 10th century. So if you imagine the early Islamic polity, you have a number of different historical manifestations of it. First, you have the Prophet, who no one denies has a kind of religio-political authority. After he dies, you have caliph successors, and you have four in particular that are seen to be the rightly guided. At least the Sunni narrative is that they're the four rightly guided caliphs. The Shi'i narrative is that the first three were usurpers who were illegitimate. They took it away from the fourth, who should have been the rightly guided one. Nonetheless, you have these four caliphs. After the four, you then have a period of dynastic rule under the Umayyad dynasty from 661 to 750. And in 750, you have the Abbasids who come into power and at least nominally are in power until 1256. The problem with the Abbasid story, though, is by the mid-10th century, they no longer control the Islamic region with the kind of directness that the Umayyads once had, or that the Abbasids early on had in the late 8th century. Instead, you've had the rise of principalities, principalities that are governed and are taken over by authorities simply on the basis of sheer power as opposed to claims of religious legitimacy. But more importantly, for me at least, was the fact that by the 10th century, you not only have the Abbasid Caliph in Baghdad, you have the rise of the Fatimid Caliphate in Egypt, and you have the Umayyad Caliphate in Andalusian Spain in the 10th century. You have three caliphs vying for the title, and you have suddenly the notion of pluralism in a very stark way. You have the plurality of political sovereigns in the case of the caliph versus the princes who would hold power as a matter of force, but you also have a plurality of caliphs or self-proclaimed caliphs. And the question is, what do you do with that? How do you theorize about that? Is there space for all of these? And as it so turns out for many jurists, there isn't. There isn't space for that. There's a sense in which there can really only be one caliph, and the rest, they argue, some sort of have a certain agency agreement with the caliph. It's an ad hoc or post hoc construal of an agency agreement that then allows the sultan or the emir, or whatever term of art you wish to use, to claim legitimacy for themselves. As for these other caliphs that are out there, that becomes a problem for the jurists, and for some, they would say, well, it's really a problem of well, it's too far outside the scope. So I look at someone like Juwayni, and Juwayni actually has an interesting conversation about this. Juwayni was a jurist who died in the late 11th century, I believe 1085. He was a teacher of Al-Ghazali, Al-Ghazali known in the West, who died in 1111 and is well known, particularly in Sunni circles, as a significant jurist. The reason I look at Juwayni is because he has a very interesting text named Al-Ghiyathi. Al-Ghiyathi is a text written not for jurists, but specifically for Nizam al-Mulk. Nizam al-Mulk was a secretary to the reigning Seljuk sultans at that time, and so Juwayni, living in Nishapur in modern-day Iran, the Seljuk sultans held some of that area, as well as areas in what would now be known as Iraq and elsewhere. And Nizam al-Mulk was an interesting fellow. In large part, he endowed, there are a number of madrasas, or Islamic legal academies, endowed under his name, the Nizamiya madrasas, one of which I believe Juwayni actually participated in as a chair, so did Shirazi as well as Al-Ghazali. And so the book itself that he writes is about what do you do when things go awry. It's what happens when political order falls apart. And so there's a sense of a tragic narrative that animates the very writing of the book. It begins with a large theory of how do you establish the authority and the legitimacy and the obligation to erect the imama, the imamate or the caliphate. Can you have more than one? What happens if you have multiple claimants to the same position? The conditions precedent, namely a contract for this position, who are the parties to the contract, and so on and so forth. And what I offer here is an elaboration of his argument in a section of the book about can there be more than one imam, and what happens if there is, or if there are at least claimants to it. And he's fairly confident, and he seems quite distressed by the idea that there would be more than one. And so Does it mean that there can't be a multitude of polities? No. He recognizes the reality that there are princely sultans all over the place. But as long as they pay heed and pay homage to the caliph, he's fine with that. And so there's a kind of plurality, but it's a second best plurality. It's not the kind of plurality, he'll accept the kind of plurality of sovereignty as long as there's always this one linchpin that holds everyone together. Which raises a serious question for me about to what extent would he recognize and grant legitimacy to a multitude of sovereigns on an equal basis in the absence of an imam or not. He does talk about the possibility of there being no imam whatsoever, and in that case, perhaps that is where we are left with the idea of, well, in the case of no imam, there's no rightful leader who can claim leadership of the Muslim ummah, the Muslim world community. We only have regional polities that hold authority, and maybe that's what we're fine with until, of course, we have the moment when we can create a new contract and have the contract of the imamate set up. And for him then, the imamate is the telos to which all politics must lead. In the absence of the actual telos being manifested, we still nonetheless aim for it. So what does one conclude from this? But before I get to that, the section in the paper that I wasn't able to complete in anticipation of our talk that was taking me in different directions that require a bit more time, and I've, again, shared this with Mohamad in advance, is on the one hand, we have the theological arguments about agency, and that is one set of questions that I think is interesting. The second the second investigation is in the idea of multiple imams or multiple polities. The third that we would want to introduce is the place of treaties in Islamic law. And this because so much of the Islamic international law literature is about treaty making. But what strikes me as interesting is the historical precedent about treaties. The precedent oftentimes cited is the prophetic precedent in creating the treaty with Meccan forces around 628, 629, which is called the Treaty of Hudaybiyah. The Treaty of Hudaybiyah was with the Prophet and the Qurayshi forces outside of Mecca as the Prophet was trying to make a pilgrimage to the holy sites of Mecca. The treaty basically said he would come the year later, and in so doing, the people of Mecca would abandon the city. There were a number of conditions that were part of this contract, including a return of any Meccans who want to come to Medina and convert. As it turned out, the Prophet breached the treaty. There were Meccan women who wanted to convert to Islam. They came to Medina, and instead of returning them back to Mecca as the treaty demanded, he held on to them and then a year later basically conquered Mecca. But what was interesting about the treaty when it was made was that it had a 10-year limitations period. It would only apply for 10 years, and after that, they'd have to renegotiate. And that particular precedent resonates, in my mind, through many of the treaty discussions that I still have yet to look at. But to the extent that I've looked at some, I felt it was premature to add it in this draft. I felt that I hadn't done enough of the due diligence I would have liked to have been able to present it to you at this event. But what troubles me about that precedent is, of course, the time limitation. And where I hope to go then is to think about what justifies the time limitation. So where does this take me? We have these three different arguments: the sovereignty of the self, the possible multiple sovereigns, the role of treaties in negotiating the relations between multiple sovereigns, although those multiple sovereigns wouldn't be the imam writ large, but perhaps something else. Part of what this raises for me is a question of is our notion of Islamic international law really a law of the second best? Is it not about the telos to which Islamic legal theory aims at least politically, but rather some sort of compromise position? Now, this has no bearing necessarily on contemporary debates about international law, but I'm mindful of the work of my colleague Jutta Bernay and her colleague Stephen Toop on the issue of international law and questioning how much it's more than an aspirational ideal, or if it's simply just that. And I leave the paper at least in a state of some. I'll leave you with the paper, and I'll turn it to Mohamad in a few minutes. in a state of some tenuousness. I'm not entirely certain, to be frank with you, where I'm going with that. I'm looking forward to comments from you and from the rest of you about whether or not the paper has legs to carry it much further than where I've taken it. Where I want to go with this in terms of the next larger project for me is to think about the paper as, on the one hand, coming from a genealogy of 3 different projects that have animated certain questions for me, but going towards something that is still in becoming. I have a sabbatical year coming up, and part of it, Michael and I were talking about, gosh, what will we do on our sabbaticals? And with a few more weeks still of classes, I'm mostly just hoping to take a nap at some point. But my real hope is to think creatively and to think creatively about, for the first time, thinking in a normative fashion. Most of my work has been about looking at the past and unpacking it and showing how it works, showing how it didn't work, how it's being used or co-opted today, and pointing out different ironies. And that's been much of the work that I've been doing thus far. But I'm now being asked to participate in projects around conversations with different theorists from different religious traditions, Catholic, Protestant, Jewish, and others, to think about dialogues across international law and religious legal traditions. Dialogues on issues of global cooperation, without necessarily yielding to the thrust of a lot of contemporary legal philosophy or theory that is animated by what someone like Adam Seligman in his book on ritual would call post-Protestant assumptions of modernity. And I'm not entirely certain where this is going, but it does seem to me that thinking about religion on its terms offers a way of in a sense, returning the gaze to those working whether in liberal legal philosophy or communitarian or others, not because the religious is necessarily something that, in relationship to the horizontal, the vertical between me, in terms of the theological, might resonate, but rather because it seems to me, by taking apart the arguments animating the religious, by taking apart the arguments that make the religious arguments intelligible, it actually offers us a way of thinking about other legal traditions that are, in a sense, seeking to do the same. And so, in this vein, I think of the work of Seligman and others on the notion of ritual. I don't know if they write in the context of religious studies, sociology, and ethnography, and one of the things that they're interested in is thinking about rituals as a way of creating what they call the world of the subjunctive, the as-if. The world that doesn't exist, but that we need in order to create some sense of order out of an experience of effectively of chaos. And the world of the subjunctive, where might law fit in? There they talk about ritual, but want to expand it from the mere notion of the religious to all notions of even the mundane. So they oftentimes give this example of shaking hands, saying hello, how are you? A student comes into my office and I ask them, how are you? Do I really want to know how they're doing? Not really, but it's a mode of engagement that brings us into conversation, that brings us into communication. And so what I'm now moving toward is the question of Islamic law and legal ordering, not necessarily as ritual, although one could frame it that way, but as a way of thinking about ambiguity, a way of thinking about the subjunctive. And here I want to think about a subjunctive in light of a very different reality than my medieval jurists thought about. And so with that, I think I'd like to conclude, if that's all right. I'm going to turn it over to Mohamad, if I may, or actually, should I turn it over to you? Okay, well, I will. Thank you very much.
All right, thank you. Let me just start by thanking the organizers for inviting me to participate in this great event, second year in a row, and thank you all for coming here today. I'm going to try to do my best here to give some constructive criticisms to try to help Professor Emon further develop this rich project, because he's got a lot of thoughts in it, but seems like he's looking both for direction and ways of putting it together to put it out there. So I'm going to read, both for your sake and my sake and for time's sake, and we'll pick up the conversation after that. So in his paper, Islamic International Law and Public International Law, David Westbrook notes, after having just surveyed the writings of several Muslim theorists on the subject of Islamic international law, that the surveyed theorists all failed to provide, quote, a thorough discussion of how Islamic conceptions of international law are to relate to Islamic theory, or of how the Islamic tradition is going to create legal authority in the international realm, end quote. I believe Professor Emon has taken some important steps in regards to tackling Westbrook's first concern. That is, Professor Emon aims to inquire into the place of sovereignty into Islamic thought and whether the notion of sovereignty is supported in terms of Islamic intellectual history. His view in the paper is that a robust notion of sovereignty does not exist in Islamic intellectual history. Now, what implications this conclusion will have on any attempt to derive a plausible concept of Islamic international law is perhaps too early to tell. If the aim is to help establish an Islamic international order that recognizes the sovereignty of independent nation states, whereby each is more or less territorially bound and have established their own set of basic institutions which are left to govern in accordance with whatever set of political principles they value, then there's already some tension. Given that in Islam, sovereignty is vested ultimately in God, we are already presented with the challenge to the view of independent states governing their own affairs in accordance with non-Islamic law. As the medieval historian Anne Lambton notes, quote, no Muslim political theory of state asks the question why the state exists. The starting point is the assumption that rights and obligations are determined and revealed by God, and that therefore he, or the divine law he reveals, is the ultimate sovereign, end quote. Moreover, the idea of a sovereign state is also difficult to establish, given that Islamic law is thought to apply to all Muslims, everywhere independent of geographical location or political association. The basis of the Islamic State, as Lambton also points out, was ideological, not political, territorial, or ethnical, and the primary purpose of government was to defend and protect the faith, not the state. Faith, in other words, ontologically prior to the state, and does not depend on the existence of any state for its recognition or validity. Now, in Professor Emon's presentation, we are taken to the site of several different areas of Islamic pre-modern thought, both theological and political, and their relation to the idea of a state sovereignty. We are taken through an informative set of sections which deal with the several debates in early Islam, including free will and determinism, Islamic natural law theory and the role of human agency in the normative ordering of the world, and 3, the status of the Quran as either a historical text subject to contextual interpretation or an eternal text. Professor Emon then moves on to the side of governance and pluralism and briefly takes up questions pertaining to the relationship between the Khalifat, Imams, and Sultans or Emirs. Now, given the limited time I have here today and the wealth of information in today's presentation, I intend to limit my comments to 3 brief issues. The first takes up the specific sites of investigation that Professor Emon brings up and whether disputes in Islamic intellectual history have been so dichotomous in nature. And if so, then how are we to navigate through these debates for purposes of making sense of the idea of an Islamic international law? My second issue raises the question of modern Islamic legal theory and its relation to the idea of sovereignty. Professor Emon early on in the paper notes that there is quite a large body of work on the idea of sovereignty in modern day writings, but elects to leave them aside. I'm curious as to what degree such writings will be left in the margins. Personally, I take such writings to be part of an Islamic intellectual history as much as the early pre-modern Islamic development. My final issue stems directly from the second issue. I raised, to use Jeremy Waldron's phrase, the dead hand of the past concern, and how much of Islamic development requires that we be limited by the juridical, theological, political, and ethical views of early Muslim jurists and theorists. So I'll take up each one of these issues briefly, but in that order. So issue 1, the nature of the debates. In his examination of pre-modern debates in both theological and political Muslim circles, Professor Emon takes us through several sites of inquiry in the relationship to the question of sovereignty. This section serves more as a historical analysis of the different debates that took place in early Muslim thought. We see that questions of free will versus determinism, for example, as playing a potential insightful role in respect to the broader question of sovereignty. I do, however, have 2 reservations about the analysis. First, much of the analysis is done in a dichotomous fashion, which I am not sure fully reflects the debate on the ground. For example, implications drawn out of the status of the Quran and whether it's a historically situated or an eternal text struck me as somewhat odd. It pits the 2 sides together, pits the 2 sides against one another without taking into consideration the third alternative of viewing the Quran as a text with ahistorical, atemporal principles of justice, equality, fraternity, brotherhood, sisterhood, as well as historical claims entailed to address particular circumstances occurring in 7th century Arabia. My second reservation concerns what can be drawn out of these debates given the natural disagreement between Muslims in the pre-modern era. But let us, for argument's sake, suppose that there is in fact only two sides in this debate. I still fail to see how the pre-modern debate is to be evaluated if we are to forward support for the main thesis of Professor Emon's paper. That is, given the historical facts about the debates that took place, we are, as things stand right now, left with no evaluative tool for determining which side of the debates presents a more plausible account of sovereignty. There's no doubt that historical facts serve an important purpose here, but it is the evaluation of those facts that I think is more important if we are to advance some claims about the possibility of an Islamic conception of state sovereignty. So my question for Professor Emon at this point is as follows. What determinative conclusions can we draw out of these debates in relation to the question of sovereignty? Will there be a winner in these debates, and do we even need a winner? Perhaps this is my philosophical intuition coming out, but your approach is very historical. Mine is philosophical in the sense that I want something to sink my teeth into.
Sure.
Right? I want to know which side I should be thinking is the better side, or which side should compel me more. And even a less popular conclusion would be to show how, despite these debates, there might actually be a concept of state sovereignty that's somewhat hidden on there, but we would have to tell a particular narrative about which side. So trying to just throw some philosophical intuitions out there. Issue 2, which I call juxtaposing modern and pre-modern conceptions of sovereignty. So early on in this paper, Professor Emon acknowledges the begged question of the centrality of sovereignty for public international law, but quickly goes on to say that, quote, this is not the place to delve into competing theories and philosophies of sovereignties. Now, I wonder though how far Professor Emon's account can go without tackling some of the modern Islamic accounts of sovereignty. In particular, given his claim that pre-modern Islamic conceptions cannot account for the idea of state sovereignty, then how useful would it be to remain committed to this narrower view of Islamic intellectual history? Professor Emon's analysis is still important insofar as it informs us that any fruitful attempt to derive a concept of Islamic international law will be hindered by early theological and political debate. The general theme of early Islamic debates on international law revolved, much like classical Western international natural law, so for example, Hugo Grotius and others, around questions of war and peace, international relations between the abode of Islam, the Dar al-Islam, and the abode of war, Dar al-Harb, and treaties between communities, not necessarily states per se, but communities. If this is the intellectual history that we seek to explore, then much like Professor Emon, I do not think we will find a robust concept of state sovereignty. However, modern writers, who are not necessarily discounted in Professor Emon's paper, but left aside for the time being, have attempted to forward meaningful concepts of state sovereignty. So the modern Egyptian thinker Sayyid Qutb, born in 1906 and died in 1966, for example, had written extensively on the power of sovereignty in Islamic thought. Granted that there are internal problems with Qutb's account of sovereignty and a strong advocacy for an Islamic overarching legal system, he does attempt to derive a concept of Islamic state sovereignty from Islamic sources, most notably the Quran. The exclusion of such accounts may be unwarranted in Professor Emon's current paper. Now, Professor Emon may want to label such views as outside his purview, such that they have been largely occupied, if not outright influenced, by modern understandings of state sovereignty, so the whole imperial notion here. But I'm not entirely convinced that such views need to be left out of the intellectual history that Professor Emon is interested in examining. It is as much part of Islamic intellectual history as the early theological and political disputes found in the texts of Al-Marwardin, Al-Ghazali, Shatibi, and others. In fact, I would go so far as to suggest that there may be a value to juxtaposing early Islamic conceptions of state sovereignty, or lack thereof, with modern Islamic conceptions in order to trace out the unique similarities, differences, developments on both sides. The idea, actually, that I'm proposing here came to me from an online interview clip with Professor Emon, currently found on the Canadian Department of Foreign Affairs and International Affairs, where Professor Emon himself suggests, in relation to Western and Islamic legal discourse, and having himself come from an Anglo-Canadian tradition of law and Islamic legal historical perspective, that we not just translate words and texts across traditions, but rather concepts, such that we aim to look for what, quote, functionally operates in the same way across Anglo and Islamic legal traditions. That is, Professor Emon goes on to say, engage with translations, quote, at the conceptual level in order to find common grounds conceptually and in ways that are expressed in different languages, in different dictions that have a symbolic value, end quote. I think such an investigation is necessary, but rather than comparatively between Western and Islamic conceptions of sovereignty, we do this within Islamic discourse in order to translate, as you say, at the conceptual level, the idea of sovereignty as developed and understood within Islamic discourse, both now and then. And finally, the third issue I want to bring up, which I call the return of the dead hand of the past, questions of methodology. So the final issue I want to briefly take up concerns the methodology of Professor Emon's account. In the paper, Professor Emon acknowledges that sovereignty in Islam should not be defined only in terms of the past, but should also take notice of the ongoing Muslim debates about the topic of international law. Professor Emon also makes a similar observation in his book, Islamic Natural Law Theories, where he reminds reformist thinkers in his conclusion not to be too eager to reconceive, refashion, or redeploy views initially developed in pre-modern times without also acknowledging the intellectual context where the models initially arose. Now, this is peculiar because reformist theorists are interesting because at some level they try to present an account that is consistent with Islamic intellectual history, but at other times reformist thinkers need to sometimes commit a sharp break from previously held positions for a wide range of reasons. Now, I wonder if the topic of today's paper allows for the type of sensitivity that Professor Emon advocates in his approach, or whether early modern debates actually work to constrain the working out of a view of an Islamic international law. There is a question of how much of the dead hand of the past do we want to allow to constrain our investigation. There's no denying, I think, that we need to be sensitive to the past and the rich debates that came forth from Muslim theorists, jurists, and so on. But I wonder about the methodological limitations placed here and their ability to help this project. So eventually, are you going to also want to break from pre-modern thinkers and say, there's nothing fruitful there, or whatever is there is consistent for their time, right? And I should probably have prefaced this whole talk by saying I also come from a particular school of Islamic thought, so I had the reformist gene kicking in when I was reading your paper. And I'm wondering how much you want to stay committed to that, and how much you want to move beyond that. So I hope some of my comments today can be constructive in helping you tease out what it is you're trying to get at, how much of it you're trying to get at, and how much you can do with it before you have to kind of put a stop to that. So thank you.
Thank you. Those are fantastic comments, and I'm not even sure where to begin, but I think I'll just go in the order that you presented them. And I think one of the first ones you talked about was this dichotomous notion in the context of sort of the theology, and you talked about we may have this pre-modern debate about is the Quran created or uncreated, the makhluk, ghair makhluk debate, and you offered this third one, a third one that certainly we can see, I think, resonates with those like An-Naim and his teacher Mohamad Taha, who would offer perhaps that third one as an example. But I think what you raised a larger question to me is, what do we do with this theological debate? And how do we see this historical debate? Obviously, it has contemporary relevance in the way people frame their engagement with the past in the present. And so there's actually a meta question that you're asking is, what do we do with the past in general, and the role of the past and the historical legal tradition in terms of claims to legitimacy, authority, and normativity today? That's sort of the bigger question I think you're asking, and I want to come to that towards the end, if that's okay. But I think to build towards that, I'm provoked by your question about do these two theological positions kind of occupy the field? Are they? Is there a winner? Is there a loser? Which one is the winner? And that to me is a fascinating way to put it, and it reminds me how I very much do operate in the historical mode as opposed to the philosophical. And so I'm mindful of the different disciplines from which we're asking our questions. And And so the question itself is provocative to me as a historian, but I think it's the right question that I am struggling with. The historian in me hesitates to answer that question. But the historian in me also wants to say, actually, maybe neither actually have to be the winner. Both actually have a historical provenance that I think no longer is relevant in the following fashion. If we think of the debates about the Quran and the medieval debates about is it or isn't it created, what it really is, in my mind, is a debate that reflects ongoing polemics with Christians in Byzantine Syria. So as Muslims expanded their empire into Byzantine Syria, you had Christians who were in that region, and what they're really talking about in that context is the Trinity. And the idea of the Quran is created or uncreated raises the following question. If the Quran is uncreated, it is eternal. But if it's eternal, then so too is God. Therefore, you have two co-eternal entities, God and the Quran, which is just one short of a trinity. And so in many ways, the makhluk, the ghair makhluk, the uncreated position, its value is really about to say that the Quran is created, therefore, is to actually position yourself as against those arguing in favor of the Trinity. Yet at the same time, those who are inclined to think of the Quran as an eternal text are very worried about over-historicizing such that you can actually relegate versus the Quran to, in a sense, a historical scrap heap, right? They don't want to avoid God's word. There's a kind of focus on omnipotence. And when they start being pressed on the questions, well, doesn't this mean that you're engaging in a Trinitarian-like argument, but just with two? They say, well, we're not going to go that route. There's a kind of, they're not willing to go that far. They, in fact, say in some of the Arabic, bila kayf, without how. We just don't ask that question. We don't go there. God is different than all things that we know. And so maybe what I think, an answer to your question, if I'm to think in the language of, and in the paradigm of a philosopher, is the history allows me to historicize the debates as being more about Muslim-Christian polemics that allow me in a sense to say this debate actually doesn't need to be relevant. This particular conversation isn't as relevant to my desire to think about the Quran in this third way or a fourth way or a fifth way. And perhaps then to get to your third, it will require the historical argument to, in a sense, recharacterize what the early theology was about. And so we do see that. And so that would be, in my sense, a way of saying I don't have to, instead of picking one as the winner, historicize both as being less relevant than we think they are, less obvious or less given as they claim to be, and then make room for the third or the fourth or the fifth. And that would make space not simply to say, well, who then should be the winner, but to offer different voices about what a winning argument can be. And here you can offer a historical argument, a hermeneutic argument, or whatnot. And so that would be my response. And that is part of a research project that I haven't done, but I think it's a question that continues to lurk in the background, and may in fact need to be part of that discussion. So I want to thank you for that. You talk about, the second one was about juxtaposing the modern and the pre-modern, if I remember correctly, the modern and pre-modern notions of sovereignty, and what do I do with the modern? And you're absolutely right. I don't sufficiently deal with the moderns other than to set up the question, as opposed to then seeing how far do they go, where do they go with their current work. And I actually take that as a very friendly amendment. I mean, I think that that's actually a really important contribution that I would need to do in terms of either whether it's in this article or as part of the larger project, is perhaps to trace the evolution of these issues into the contemporary period. But I want to suggest that your second point and your third point about sort of the dead hand argument that you make reference actually overlap in very significant ways. Is that, well, what do you do with the pre-modern and the modern within the Islamic context, and then with those two in relationship to outside the Islamic context? I mean, that's it's an interesting sort of triumvirate of sorts, and I think you raise that in a very stark way with the second and third point. And so let me just more generally speak to it, and then I'll come to maybe more specifics. I struggle with that question all the time. It is not an easy question to deal with for the following reasons. It's very hard to get away from the pre-modern when you're talking about contemporary Islamic law and debates on Islamic law today, because the pre-modern finds its way. The past is yet ever present. So if I am looking at the Jordanian family code, I'm going to find provisions of family law and marriage, divorce, inheritance, and custody that I can trace to medieval fiqh books from the 11th, 12th, 13th, and 14th century. If I'm going to Saudi Arabia and I want to know the private law outcome on the issue of tort, I will be going to 4 books from the Hanbali tradition from the period, the most important being Al-Mughni by Ibn Qudama, who died in the 1200s. And so in many ways, when I think of Islamic law today and the debates on Islamic law today, it's very difficult to escape the past. And so I'm not as, so while we do have this historical periodization of the pre-modern and the modern, I'm mindful that from a presentist perspective, the line as far as normative considerations are concerned, philosophical consideration, is less distinct. It's a distinct line for historical purposes, but not so much for normative, at least in the way that I see how things are going. And so let's take, for instance, gender reform as an example. Women living under Muslim law is a particular movement trying to reform Islamic family law in various Muslim countries. And they will engage this kind of historical analysis of Islamic law in the interest of making the break to human rights law, right? And that's the argument that they make. But then you have a group like Musawa, which developed, I think, around 2005, that want to do the same kind of historical argument, but not make the break. They want to stay true to an Islamic argument and framework of analysis, because for them it matters. For them, questions of Islamic authenticity matter, their audience matters. And so what you have then is, in both cases, you're dealing with the past. You're dealing with a prior tradition that is said to be very normative and controlling in the present. So I don't think one can actually depart from the past. I actually think that past becomes part of the ongoing conversation. At the very least, the past is the interlocutor with whom the present reformists are debating. So even someone like Tariq Ramadan is invoking notions of the past. The minute he brings in the notion of maqasid, as you know, he's talking to Ghazali, he's talking to Shatibi, he's talking to Arazi and all of those folks, right? And so, and it's not even just Tariq Ramadan. There's the Cordoba Initiative out in New York, who are developing the Sharia Index, an index of human development to be applied to any country, and they're developing an index based on what they call the Maqasid model. And so even it resonates on so many different levels. But then what does that mean about modern commentators? And here you referenced Sayyid Qutb, but we could reference a number of people. Yeah. You know, Qutb, there's Maududi, there's even, you know, Ramadan, if we want to take a more modern, a more recent individual. And I will be frank with you, I have a bias where I worry that they don't actually pay, they actually represent a considerable break in some ways. I always worry with some of these folks, and perhaps it's a bias that you've now caught me on, and I need to be more mindful. And I think it's fair that you caught me on this, and I think you should have caught me on it, and you did. Is that I haven't paid much attention to the moderns. Frankly, when I read them, I find them uninteresting, which is sad, and maybe it's more a reflection of my impatience with them. But there is a sense in which even the moderns are mindful of the past. Even when they're making a break from the past. And the way they construe the past, though, the past from which they're breaking, I think is they do short shrift to it. I don't think they actually understand what's going on in the past. So when Maududi or Qutb are making these arguments, there's a strong post-colonial element in their writings that force almost a reification of the past, that make it very easy to break from the past. The more you can reify the past, the more you can reduce it, the easier it is to put it aside. And that's one of my arguments with them. But I think that you're right in saying maybe I need to give them a little bit more attention. Right. I think that that's fair, and I think part of it is a function of my training as a historian of the medieval past, and your starting point as from the reformist perspective, I think forces me to really think about that. And I think it's fair. In that regard, then, I can imagine myself not just looking at someone like Maududi But I think Javed Rahman is someone who's trying to write in this vein. Khadouri did a little bit of work in this area.
Ghanouchi as well.
I'm sorry, Ghanouchi, and I even think Mahmasani has some work in this area. So I think you're right, and I would concede that point to you very, very, very much so, and very gladly so. So I think that addresses both
Sure, yeah,
number 2 and number 3. And I think,
mean, but I think,
yeah, please.
but the colonial, I mean, this argument out there that, we have to be mindful of the colonial influences and how this shaped, and now when Muslims talk about the state, they're talking about a modern conception that's influenced by French and the English and so on. But to me, this has just become part of the intellectual history of Islam, that we do have to wrestle with this as part of the story now being told, and not try to go back to a pure time before these ideas or concepts had influenced Islamic thought. I mean, Islam had to respond to them in some kind of way. It was aggressive at first, but now we're trying to break away from it. But
no, I think that's fair. I think let's look at a very specific example, like Malaysia, for instance, right? So Malaysia is an interesting example because if you look at the ruling party structure under UMNO, under Mahathir, for instance, Mahathir's UMNO position on Islam became much more pronounced as he was trying to gain the Muslim Malay vote, but his notion of Islam was a much more modernizing form that was very favorable towards the state, saw the state in, but also saw the state as very much a global participant. And you sort of saw that with Badawi's notion of civilizational Islam, Islam Hudari, which was one of those things that he pushed forward. In opposition to UMNO came PAS, which had this very strong Islamist notion of what a Muslim Malaysian state would look like. So, for instance, when they were in power in Kelantan, in a state of Malaysia, in one of the provinces of Malaysia, they passed the Hudud Ordinance Bill, the Islamic Criminal Law Bill. Now, criminal law in Malaysia is not a provincial matter, it's a federal matter, so it had absolutely no force. But what you find there are two very strong and very distinct notions of Islam competing for one another, competing for legitimacy. So what I think that what I think I'm seeing, and perhaps this is part of a larger conversation about reform, is that there will always be the past, who will always look to the origins as a way of claiming the most legitimate model of Islamic law, the most traditional, the most textual, the most literal, and the most literalist. And there's a sense in which I'm most worried about that group. The others in the middle are doing something different, and I'm not entirely certain what they're doing, but so much of what my work has been about has been how do you deal with those who read the past as if it were present, failing to translate. They don't actually do the translation into the modern context. Maybe the Mahathirs of the world were doing something else. Maybe the Mubaraks of the world, for instance, were doing something when they were trying to incorporate Islamic law. I think there's a story there to be told that's not just about post-colonial, but also that is post-imperial, in the sense that for the Muslim state, not only are they the product of a post-colonial period, but they are the product of a post-imperial history where they were at once an empire, an Islamic empire that was then colonized and that was then broken down and then had independent movements. So I actually want to complicate the picture twice, not just calling it post-colonial, but also post-imperial. And then my question then is, how would we then look at these international law theorists who are writing reformatively about Islamic international law? Do we see them differently in light of these two posts, being post-imperial and post-colonial? That might be perhaps where I would want to go. But I think that it's a fair critique.
Okay, we'll then turn it over to the audience for some questions.
That's a question later.
Oh, thank you very much. I know very little about Islamic law or the Islamic religion. What I know I got mainly from Mohamad when he was one of my students. But in thinking about medieval natural law in the Christian tradition, and listening to you talk, I was brought to mind, what was brought to my mind was Aquinas in his attempt to bring together Aristotelian rational philosophy and medieval Catholic doctrine. And one of the doctrines that he developed was what's roughly translated as determination of common notions, which is where the natural law has certain principles or concepts that can be, putting it kind of crudely, interpreted differently but legitimately within a range of acceptable options, all of which are acceptable from the point of view of the natural law, and it's part of the function of human law to render those determinations. And I was wondering whether there's anything like that in medieval Islamic law which might partly explain or illuminate some of the controversies that, for example, plurality of sovereigns and so on, and their role within an Islamic legal framework.
You're almost as able to answer that as I am.
But you're the guest of honor.
Okay, so I was going to ask Mohamad if he wanted to take that question. I think that the work that I did on Islamic natural law theory had to deal with, I very narrowly framed the question, namely in terms of the ontological authority of reason. Is it a source of law where there is no source text, here meaning a revelatory text of some sort? And in that particular context, you definitely seem to see two camps that start from two different theological positions but coming to the same position in terms of making a natural teleological argument about a nature that's fused with value, so the fusion of fact and value that we've seen in other contexts. Where I think there might be some overlap in what you've articulated from the Aquinas tradition is again really in the Maqasid, perhaps the Maqasid idea, where yes, there are certain notions or certain values that can be posited, and the law can aim towards those values, and there's a realm of debate that's tolerable. And in fact, where there is no text, you can reason to a particular legal outcome as long as it has a correlation to those aims or values. The problem, though, is of course what those values are, and they're just posited. They're posited as 5 by Al-Ghazali: the protection of life, lineage, mind, property, mind, and religion. But when he writes about them, he talks about them as, he first says these are the values that any society would have if they are to be governed by law, and then he lists what I argue is corroboratory evidence from the Quran that supports the existence of these values. Others will say the evidence establishes and creates the values, is determinative of the values. I argue that the scriptural evidence is corroborative of it. But it does force a question in terms of, well, what are these intuitively positive values? How do you come to them, or whatnot? They're definitely so. The short answer is yes. There is a definite parallel in terms of what you can argue for. The qualification is I don't know how we would necessarily arrive at what those values are. But the connection you want to make between that and maybe the notion of multiple sovereigns, I don't see that necessarily. I don't see that as at least from what I wrote about in one context to here, I don't really see the multiple sovereigns as having the same issue. The plurality in Islamic law is oftentimes justified as a result of human fallibility. And one might say, well, you can talk about, in a sense, the limits of the sovereign today in relationship to God as a way of seeing that. I haven't seen my jurists make the connection between the political stuff and the legal theory stuff. It doesn't mean it can't be made, but it does raise a question for me now, so maybe that is worth linking. I haven't thought about it, but thank you.
Thank you to you both. At the risk of sounding a little ignorant about the matter, to be honest, much of your paper, much of what you're describing went over my head. And I think it's important for me to understand it in a way that I can discuss it with others. And I plan on reading the paper later, but for now, if you could summarize what you think I, as a layman, I, as a Muslim, or I, as somebody who's just interested in the matter, should get out of this, just so I can understand it and maybe have this dialogue with colleagues of mine or friends of mine after reading your paper.
So I think that, for me, I think there's, in terms of both what I have written, I think the conversation that's come from my conversation with Mohamad is the takeaway, I think, is that if the notion of Islamic international law relies on a robust notion of sovereignty, I raise questions about whether such a robustness actually exists in the historical Islamic tradition. If international law doesn't require a robust notion of sovereignty, and thereby if Islamic international law doesn't require a robust notion of sovereignty, then there's no problem. But if sovereignty is a significant issue, and I set up the question, and I set up the possibility of the robustness being important as a result of perhaps a post-UN charter world, maybe not a pre-UN charter world, but maybe certainly post-UN charter, given some of the references to the equal sovereignty of states being protected. If that's not too much of a stretch for me, and I place that with a lot of caveats given the way others have written about whether sovereignty is a necessary element or not. But if it is a necessary element, I think there's concerns about what Islamic international law means. And for me, it raises serious questions about a commitment to robust notions of pluralism. I see the pluralism problem in the context of the work I've done on the dhimmi, the non-Muslim under Islamic law, who is subject to some fairly discriminatory rules if we judge them from a 21st century perspective. There's no doubt about it. The problems I have about pluralism there are some of the same problems about pluralism I have here. And so part of the larger question then is, so if you were to have a conversation with your colleagues afterwards, some of the talking points might be, gosh, do we actually need to have a robust notion of sovereignty? Does Islamic law, to the extent it has an Islamic international law, does it recognize equal sovereigns, or rather are other polities that claim to be sovereign really just targets for ongoing conquest and empire? In which case, is Islamic law really just about empire, or Islamic international really about expansion and empire with treaties and as temporary stopgaps where we're not particularly powerful? And it forces a real question then of how can you imagine international cooperation? How do you think of global ordering? How do you think of the way in which Muslim polities today operate at the international level with each other and with other powers and sovereigns, whether in international organs like the WTO or the UN or whatnot? Those are questions. For me, the real push might come at how much can the international community press Muslim countries who put reservations on international treaties and limit the scope of their ratification in the interest of Sharia, for instance. Can you actually press them a bit more, and how much can you press them? That might be one of the areas you can take this, but this is more of an abstract conversation than that specific treaty-related discussion.
Okay, I'm just going to try and work my way through a question here, and it may be moot, so just bear with me for a second. So the idea of the work is you went back, you analyzed these kinds of medieval thinkers, medieval thoughts on the idea of sovereignty itself, right? And the idea that seems to have emerged is that sovereignty is a very difficult thing to have established in that context. As Mo said, it just doesn't seem to be there. So there seems to be this weird disjuncture between your conclusions and your aspirations for the theory, and the disjuncture is this. The current context of debate about Muslim state law or Muslim international law presumes the idea that state law is a coherent thing. And state law seems to presume sovereignty. So if there is no sovereignty, then what you may have discovered is that, in fact, references to the past are discursively moot here. So you seem to have not offered insight or lines of debate to the parties that might be engaged in this kind of an undertaking, but actually shown that that entire endeavor, any attempt to justify contemporary policy on the basis of reference to the past, is itself invalid. Is that an acceptable conclusion?
No, I think that's actually a fair way of suggesting that for those who are interested in talking about Islamic international law in general, I raise serious questions about the coherence of that idea.
So then you would seem to not, it wouldn't be in your interest to consider contemporary or more recent Islamic theories of state law and international law, but that would be the beginning point of any conversation.
Yeah. No, I think you're right.
Okay.
I think he's a reformist like me.
Yeah. I mean, the modern conversations would be the starting point. The modern ones are invoking the past to make their arguments about the present. And I want to say the past doesn't help you the way you think it does. And you're not actually accounting for the movement from the imperial to the post-colonial modern state.
So at that point, though, the discussion of the past it loses its normativity, and that's the point of the project. There is no normativity in these references to the past.
Yes.
Any normativity that emerges is actually going to be a function of our post-colonial understandings.
Yes, absolutely.
Okay.
And I think if I could build on that for just a moment, I mean, a lot of the work that I've done is really like that, where you unpack the past traditions, you reveal what the animating purposes were back then, only to illustrate that the ongoing constant citation to it makes very little sense once you unpack it. So just to give you an example that I'm a little bit more comfortable with because I just finished it is, you have, for instance, the treatment of non-Muslims. So for instance, in Saudi Arabia, for instance, let's take the example there. If I'm hit by a car and I am killed, my family can claim wrongful death compensation for me because of that. And the wrongful death amounts are defined as follows. If I'm a Muslim male, my family can claim 100,000 Saudi riyals. If I'm a Jewish or Christian male, they can claim 50,000 Saudi riyals. And if I'm anything else, 6,666.67 Saudi riyals. This was advertised and put forth on the Indian Consulate of Jeddah's website a number of years ago. And so I was curious about this. One, it's obviously patently discriminatory on the grounds of religious belief. Obviously, if it's a woman of those, they get even half of what their co-religious would get. So there's a gender element there too. If you look back to medieval Hanbali legal treatises, what you find is, if again you're claiming wrongful death charges, wrongful death compensation, a Muslim male who was killed, the family can claim 100 camels. For a Jew or Christian male, 50 camels. And if you're anything else, 1/15 of what a Muslim male would get. Interesting, 1/15 of 100,000 Saudi riyals is 6,666.67. So there's a direct reference to a medieval source for modern purposes. And what I show in that context, in the historical context, is there was a reason why they had this argument back then. A reason couched in terms of Quranic notions that were interpreted in the context of superiority and inferiority, a model of hierarchy that made sense in light of an imperial context, an imperialism that, while perhaps as a matter of history was falling apart, but as a matter of normative theory underlying the law was still preserved as the vision of the law. And what I want to suggest is that if Saudi or other countries are going to maintain these rules, and very few do, but they're still part of the common lingo, one has to understand that there is a fundamental disjuncture between the past and the present. So I cannot ignore the fact that Saudi Arabia is an international participant, a signatory to a variety of conventions, and that all of these make claim upon the intelligibility of any rule that comes out of that system in a way that it did in the past. So yes, you were absolutely correct in working through the question. The implication is that the past becomes irrelevant. In the sense that it becomes illustrative of some of the dynamics at play back then, and I think then revealing of the kinds of dynamics at play today, only because they're not, or they're not being accounted for fully in the modern context. Do you have a follow-up?
Yeah. Okay. I mean, I appreciate your response. It's definitely enlightening. As you were talking, something else occurred to me. I might want to push my original question even further and say that it might not just be a matter of the implication of demonstrating the mootness of the historical argument might have greater implications than just saying maybe we should start with contemporary accounts of the Islamic State. Why bother casting this kind of a question in that limited context? Why not just say, listen, if sovereignty isn't a function of Islamic history until these kind of contemporary shots at it here and there, why not just say when we're talking about international law and when we're talking about states in the context of international law, why shouldn't we just talk about international law?
And I think that's again, that is an important part of, I think, the larger project that I'm trying to engage in, is the more we can recognize what's going on by the reference to the past. In a sense, it is in a sense perhaps not framed in a philosophical language of a break from the past, but rather a recognition that the past has limitations. But I'm mindful that for present purposes, it's very difficult to get away from the language that the legitimacy that reference to the past still brings. So then the question is there a way of then engaging international law in a global environment that is mindful of the interests of these other countries, not necessarily in the fashion that we're going to create an Islamic international law as a parallel system, although that is oftentimes put up. You see these efforts to create an Islamic this or an Islamic that, or almost kind of ghettoizing the notion of the Islamic in relationship to what already exists in other societies. But I do think that it does force those who would rather create sort of a reified notion of an Islamic international law, it forces them to engage in a more robust conversation with the representatives of international law writ large. So in that sense, yes. Was that my larger aim and project? Absolutely. Does it mean simply that if we get rid of the Islamic element, we only have international law? I don't want to go that far because I'm mindful of Anthony Angi's work on the possibility of international law's ongoing imperial venture. And so I want to be mindful that in giving up one, I'm not asking to accept another wholesale, but I am asking to say there may be legitimacy over there too, and can we find a way to it as well? So, but that normative argument is not one that I'm necessarily certain how I'm going to articulate.
Okay, thank you.
So you presented the idea of sovereignty as from what I understood, more of a dichotomous position, that you can either have a sovereign state or an insovereign state, basically. So the first question I'd have is, what would you see as the opposite of sovereignty in an Islamic context? Is it the empire? Or, for instance, in Islamic history, we have the idea of what's called istitnas, which is the idea of I guess, like a European Union kind of system, where you have states that are collaborating and they have treaties between one another, so people can freely move between one state or another without a specific documentation, such as a passport or anything like that. Do you see anything in between? What I'm trying to get at is, do you see anything that's less dichotomous in between a sovereign and an insovereign system, where you have kind of a quasi-sovereignty and relationship between states?
Well, I think if we look at the different ways by which I think about the argument there is, one clear notion of sovereignty is simply the sovereignty of God, right? And there's a claim that there is no sovereign other than that. So one way of thinking about this is, there is no sovereign state, there's just God, and then whatever it is we organize ourselves. But if we take that and put that to the side, and we think about, well, we're really thinking about territorial authority and control, it seemed to me that at least historically, there were different developments. You had that very monistic imperial model, which you had certainly under the early caliphates, and represented perhaps early on by Muhammad's initial unification of the Arabian Peninsula, Omar bin al-Khattab's expansion into Iraq, into modern-day Palestine and Egypt, as well as the Umayyads, who up until about 720, 730 were continuously expanding, and then had a series of defeats as well as a concretization of the borders. You had the concretization of borders with the Abbasid period, and then at a certain point, the disintegration of the robustness of their control in their outlying frontier areas. And in that particular context, as the Abbasid Empire is becoming much more fragmented, where control is focused more around Baghdad, it's in that context that people like al-Mawardi and others are writing. And it's in that context that they're also noticing the rise of the Fatimid Caliphate and the Umayyad Caliphate. So to me, it's perhaps not surprising that much of the literature that comes around this issue of governance in Islamic law is actually coming up around the 10th century. which is when, in fact, this became much more problematic of an issue. And so my response to you then is, for those like Juwaini, who I write about here, or Mawardi, the argument wasn't it's either one or nothing. It's either empire or nothing, or it's an empire. No, they had a number of different models. So Juwaini, as I write in the paper, refers to what happens when you have an absence of an imam entirely. Well, then what you have are different emirs that assume authority and control. As to what their relations will be, that's not his question, right? His question isn't, well, what kind of relation will they have? His question is well, what do you have in terms of management of control and authority? Because he's concerned, he says, without an imam or without a ruler or without an emir even, people are going to be left without protection, without guidance, because for him, the notion of the leader is actually very much the notion of the teacher, the notion of he who shall guide the people. And without a leader, the people are subject to whim, to disagreement, to factionalization, to violence, and utter destruction. He uses that very severe language of destruction without a leader. So at the very least, you need to have an emir, which is not an imam, doesn't rise to the level of the imam, but is simply someone who can maintain control through force, coercion, or other means. As to the relations between multiple emirs, he doesn't really talk about it in this particular selection that I reviewed. Does that mean it didn't exist? No, you certainly have multiple polities that were both warring against one another, but also had relations with one another. And so what I don't want to be taken as saying is that there's either the imam or nothing, imperial or nothing. You certainly had a variety of different, at least historically, different regional authorities that existed. But for me, the question isn't what did we have historically, but rather what do all these imply about the notion of sovereignty as we understand it today and as they understood it back then?
So if I could just follow up on that, have you thought about looking into the Shia texts as well? Because from what I understand, is the Shia imams and the scholars talked about this extensively as well, about sovereignty, about the presence or not the presence of an imam or an emir. Mm-hmm. There's a lot of, I know Abdul Qahir al-Baghdadi, even as early as the 2nd century, was writing about the idea of multiple sovereigns and what is the position of that. And just one more thing, it was mentioned before about the evaluative nature of having multiple sovereigns. If we look at Islamic history, when we had single sovereigns in the Umayyad Empire, the Umayyad Empire lasted not for a very long time, less than 200 years, I believe. But then when you have this kind of fragmentation in the Abbasid Empire, it lasted a lot longer. It lasted almost 500 years. So in terms of an evaluative, looking at it, as evaluation, fragmentation actually helped, and having multiple sovereigns actually prolonged dynasties. You could argue that. I would argue that.
Well, that doesn't really work out with the Umayyad transition to the Abbasid. I mean, remember, the Umayyads were overthrown by the Abbasids in a revolution on the grounds that they were not representative of the people. The Umayyads had a very strong Arab focus, which really upset everyone else who wasn't Arab, but who nonetheless came under the sway of the empire. So the Abbasids came in on a quasi-Shi'i/Persian/ I wouldn't want to go say multicultural policy. I think that's a little too extreme, but it wasn't, in my mind, I mean, at least historians seem to suggest that the way the Umayyads were going, it wasn't going to be very long that they were going to be able to maintain power. And I don't think it's about the fact that they were a singular versus this fragmentation. I don't think that was what explains the distinction between the Abbasids versus the Umayyads. I'm a little bit hesitant to say that. On the Shi'is, I have not looked at the Shi'is, and I would probably want to look at them. But I'm inclined to perhaps think about Shi'is both pre and post Safavid Empire, and I would want to make that particular distinction, just because the existence of a Shi'i empire like the Safavids will obviously have some impact, one would assume, in terms of how they think about political authority and sovereignty, just because since prior to that, they weren't really in majority, they weren't actually controlling, and they were oftentimes quite considerably persecuted. But I'd want to consider it.
The Fatimids as well, Shia empire as well. So
yeah.
Thank you. I would like to ask you whether perhaps you, so I should start by saying that I knew very few of the names that you mentioned, so I can't relate them to a particular historical period, so maybe my question is mistaken, but I got the impression that your focus, and perhaps in this you're either reflecting an existing debate that you're part of, and also your background as a medieval historian, but perhaps you're looking at the wrong period, in the sense that if you check Christian scholarship at the time, you wouldn't find what you would now recognizably call international law. Perhaps because the idea of nations in the modern sense is a product of Westphalia, perhaps the century or so coming towards it, which is why, for example, we talk of Grotius as the father of international law, not of, say, Aquinas. Right. So perhaps, and I should add that when people are now looking back at the history of international law and trying to find its origins in medieval times, what they find in medieval times is lex mercatoria, that is not law of nations, but rather law of merchants. Yeah. So perhaps if you focus more on 16th century Muslim scholars, you would find more that would be relevant, because, and in particular, with particular reference to the question of sovereignty. So sovereignty perhaps did not figure out prominently in those debates because the concept itself was not that familiar in 10th, 11th century, whereas in 16th, 17th century it becomes much more important and central.
No, that's a great question. So why this early period that I focus on? Well, one is the modern literature on Islamic international law starts in that period. They go to Shaybani as the first, as in a sense, the father of Islamic international law, and he was in the 800s, if I remember correctly, or maybe no, sorry, he was 8th century, I think. I can't remember the exact date of his death. So you have that source text. You have this genre of literature from the 10th century and onward that actually addresses very specifically the obligations to create a political entity, a political ruler, and the implications of that from the 10th century onward. But I think your point about looking much later is an important one. I'm just mindful, though, that part of the reason I'm hesitating, and perhaps it's only because I don't know my international legal history and international legal theory very well, and I'm be happy to please be corrected by this, is that I'm mindful that the kinds of questions that I'm trying to explore from the context of Islamic international law or Islamic sources may resonate very differently on the Christian Western side, not simply because there was a much later development post-Westphalia, but I think about the investiture controversy of 1126, when the Concordat of Worms from 1126, the Galatian doctrine of much earlier, the implications that had on the division between the sacerdotal authority of the church versus the authority of the state. And what worries me is how much of that matters in the international law story a la Grotius that doesn't necessarily relate to the story that I'm trying to tell, the kind of division and demarcation of different zones of authority, sacerdotal versus other and otherwise. And I just don't know, but I think it's worthwhile for me to explore that. So you're thinking post-1600s, thinking about what's going, because at that point what I have is I have the Safavid Empire, I have the Ottoman Empire, and then I have the Mughal Empire. I still have 3 different imperial entities at that particular time that I can certainly engage with. I'd have to also see what's going on in North Africa, but no, those are different possibilities.
So I'll just add a small point. I'm actually not an expert on the history of international law, and I'm sure that Grotius was, not coming out of the blue. He was working in a particular tradition or against a particular history. But perhaps I could narrow my point only to, or specifically to, the question of sovereignty, which I think has become a much more prominent concept in a world where sovereign nations are something that is more part of kind of the political environment.
Yeah, thank you.
I'd like to use my power as a host to ask a question. I was having a hard time getting my head around the question, does Islamic international law need a robust notion of sovereignty? And thinking whether your question, whether it also means, does Islamic international, can we find a robust concept of sovereignty in Islamic international law history? Can we actually find that concept being used or practiced? And then also it led me to think about, well, is this a particular species of the general question? Does international law need a robust concept of sovereignty? Mm. And I think what was blocking me is I can't answer that question because I want to ask, first of all, what kind of international law? Or which norms of international law? So for example, at least two possibilities. For example, you might ask, well, if the international law you're thinking about is something like Article 2 of the UN Charter, which doesn't establish but tries to recognize, or in some sense codify, the equal sovereignty of states. Or if you're thinking about the 1933 Montevideo Convention, which lists or tries again to codify all the criteria of statehood, or something like the Lotus Principle, which attempts to protect sovereignty. If you're thinking about that kind of international law, then you think, well, of course it needs a robust notion of sovereignty because it's trying to recognize it or even establish it. But on the other hand, if you're thinking about the kind of international law which is meant to limit or bind even sovereign states, which can remain meaningfully sovereign, such as international human rights law, then you think, well, that's actually not the kind of law which needs any robust notion of sovereignty. Actually, it's trying to do very much the opposite, trying to constrain it, limit it, prohibit certain forms of government. So this led me to think, well, that part of the question probably needs to be, before I can even answer it or know whether your answer is a good one or not, I need to answer that question. What kind of international law? It's not a singular thing. It's a complex, shifting, diverse set of normative practices with different content and so on. But if it is the case, then what could we find in the Islamic legal history, which I'm just as ignorant as most? It looks like the kind of Islamic law that you're concerned about looks much more in characteristic and structure to something like human rights law, international human rights law, has certain affinities with it. The natural law theory of Grotius certainly has many affinities with human rights law, precursors to international human rights law. And in that case, you can answer your question quite differently. You can say, well, no, it doesn't need a robust notion of sovereignty because it's trying to very much limit sovereignty in those ways. So I'm just wondering whether there's any prompting here to try to give me more about the question. What's meant by the
I think the
setup?
I think you've prompted all the right questions that I'm still exploring. I mean, I think that that for me, what's been interesting is to read as I'm going through. Really, I think you're right in suggesting that really at the end of the day, the real question is sovereignty relevant for international law? What kind of international law are we talking about? To me, that's actually part of the question I'm aiming at, and it comes from a larger collective group that I'm working in, where we're trying to think about religious traditions in light of international law, wondering, well, what do we mean by international law, in what level, at what state? And I keep thinking of Anne-Marie Slaughter's work, A New World Order, where she really she recognizes that at least the notion of the state as the dominant player on the global scene seems to be taken down a few notches, but without giving up the state, she recognizes different notions of sort of transnational actors or whatnot. And it's that combined with the sort of anecdotal story I told about Koskiniemi that makes me think that part of what this intervention is on the Islamic law side is perhaps also a way of thinking about what international law is too. And so I don't have a really good answer to the really foundational question you asked, in part because I'm hoping to offer an account of the Islamic model that might put me in conversation with those writing in the international law sphere. So if I'm thinking about trade relations, maybe I don't really need a particularly robust notion of sovereignty when you've got multinational corporations doing a lot of trade or whatnot. But if I'm thinking about immigration law or citizenship law, then I do. And so I'm wondering then, for me at least, I don't yet know where this is going. So that's part of what I think Mohamad and I have been struggling with, is like, well, where are you going with this? And I'm not. I mean, it really is a work in progress, and I'm coming. And most of the everything that you said is actually questions that I'm still struggling with. So I wish I had better answers for you, but I think that we're both asking the same questions, perhaps. I'm just directing it to my tradition of study, and maybe you're directing it to a slightly different one. But I think we're asking the same questions, and my hope is that whatever I end up with and whatever you end up with allows us to have a conversation across traditions, but on the same idea. And that's kind of what I did with the Islamic Natural Law book, in the hopes of having conversations across traditions, and that's what I'm hoping to do here. So all I can say is your questions are my questions, and hopefully we'll have different answers, but the answers will show that the commonalities operate at a very different level.
We have time for one more question.
Okay, good, because it speaks to what you guys were just talking about, and I'm not sure you guys are asking the same questions, or can be. Mike's asking about understanding the concept of law, simpliciter, and the concept of international law as a subset or as some related concept to that. I think that's fair. Whereas I think that if you're trying to talk to the history of discourse on this topic, particularly within Islamic politics, then you don't, I feel like talking about the concept of law simpliciter is not what you're after. You're actually after, if we're having debates about the nature of international law or how Islamic states should understand it or how they should be motivated on the basis of their historical argumentation, then you're actually after the conception of international law, or of sovereignty at least, at play in the history. So you might find out that it is a function of Islamic arguments, political argument, that this is how we understand international law. And that's what you have to contest with.
Yes, yes.
Right? So only after you find out whether that's even there or not, or a feasible move within the kind of political discourse, only then can you start to have a conversation with this line of dialogue, which is the dialogue of the concept simpliciter, generally speaking. It would seem that...
Yeah, I see what you're saying. I mean, the reason I'm hesitant is that, and this might just simply be an issue of method that I'm approaching. So much of what remains for me to do is, and I think you're right in the sense that the sections that exist in the paper speak to your point that this is a question that actually precedes some of the questions that Michael was suggesting, and I think that's fair. But where I see the paper going is actually looking at the actual legal doctrines that were animated by, that jurists did develop, and trying to unpack them for what they reveal about the notion of sovereignty. And so, in many ways, I'm a little bit anxious about whether I want to agree with you or not, only because the same people that were writing this political theory stuff are the same people that are writing the legal stuff, and they're the same people that are writing the legal theory and the legal doctrine. So when I'm reading someone like Al-Juwayni or Al-Ghazali, I'm reading him for all three. And so I'm mindful that the divisions, I need to be mindful of how I'm dividing these up. I don't know if I can honestly say at this point that you're absolutely right, the sovereignty question precedes, and before I can ever get to Michael's questions, I got to first ask these other ones. To a certain degree, I do agree with that. I'm not so sure, though, because the role of legal discourse and legal rules and the regulations that developed has implicitly, in my mind, a political connotation that reveals assumptions about the underlying notion of the sovereign. I'm going to have to go through that first before I can actually, I will have to go through that as part of actually the question that you're asking. So it's not entirely prior to Michael's question. It is to a certain degree, and the theological and the political stuff that I have outlined in the paper suggests that. But what has yet to come, I think, forces me to contend with Michael's question as a way to also, in a sort of almost in a mutually reflective way, to sort of think about both at the same time. Does that answer your question?
Oh, I think so. I would just think that the first account is to try and dredge out a conception of international law or of sovereignty from the from a specific set of historical documents, or a very specific historical context.
Yes.
Because the point of the project is to speak to how that historical set of datum is brought into contemporary debate.
Yeah.
Right?
Yeah.
So you're talking about dredging up a conception of something at play in a particular history.
Yes, okay.
And that's a different project
than
than trying to talk about what that says about the concept more broadly construed.
Yes, no, I think I
All
see
right.
what you're saying.
So it's basically you're polling a different
Yeah.
set of evidence, or a more particular set of evidence. And I think once you get that initial, your conclusions on the basis of that initial data set, then you can have a conversation about how that relates to this different kind of a project, which is about how we understand
International law. More
simpliciter,
generally. That's, no, you're
derived
right.
from all contexts.
Yeah, no, that's right. I
So
think that's
what I
right.
want to say. So you can't actually talk, you can't answer
No.
Mike's question a priori.
Not
No,
immediately.
not immediately, no. And I think that you're right. No, I think that's fair. That I would have to first think about the sources that I'm using, what they reveal about sovereignty in my context, before I can then think about. No, I think that's right. No, you're right.
And I mean, in a sense, Mike's question reveals the tensions at play here.
Yeah.
That there are two sets of data that you have to contend with. Those coming from history, from the present back towards history, and those coming from the history towards the present. And that's going to be the muddle that you're going to have to
Yeah.
untangle here. And that's a hell of a knot to deal with. But
who best to deal with it?
I think you do have to distinguish between two different objects of inquiry and how they relate.
Thank you. That's really helpful. I appreciate that.
Well, please join me in thanking Professor Emon and Mr. Al-Hakim for a wonderful discussion today. Please do stay as well after for some food, but thanks.
Thank you very much. This has been really helpful for me. I want to, and I also want to say thank you very much.
Thank you
It's
for the
it's
paper.
been wonderful. Thank you.